Session 53 of Unit 5 of Industrial Relations and Labour Legislation of 6th semester BBA of Mangalore University. Workmen's Compensation Act 1923. This act marked the beginning of social security system in India. The main objective of the act is to impose an obligation upon employers to pay compensation to workers for accidents arising out of and in the course of employment. It also helps to reduce the number of accidents, to give workers greater freedom from anxiety, and to make industry more attractive to workers. The main features of the act. The coverage. The act covers all workers employed in factories, mines, plantations, transport undertakings, construction works, railways, ships, circus and other hazardous occupations specified in Schedule 2 of the Act. It does not apply to members of the armed forces, casual workers and workers covered under the Employees State Insurance Act 1948. State governments are empowered to extend the Act to any hazardous occupation. Administration. The commissions appointed by various state governments oversee the implementation of the provisions of the Act. Benefits. The employer is liable to pay compensation to a workman for all personal injuries caused to him by accident arising out of and in the course of employment which disable him for more than 3 days. The Act further provides that if a workman contracts any occupational disease specified in the third schedule, it shall ordinarily be deemed as an employment injury. The amount of compensation to be paid depends upon the wages, age, and the type of injury of the workman. The employer is under the obligation to pay compensation within 1 month from the date of which it falls due. In case an employer makes default in payment, the Commissioner may direct for recovery of the amount of arrears together with interest. If in the opinion of the Commissioner there is no justification for the delay, a further sum not exceeding 50% of such amount may be recovered by way of penalty. Employer's liability. The employer is not liable to pay compensation in following cases: where the injury does not result in total or partial disablement for a period exceeding 3 days, where an injury not resulting in death caused by an accident is directly attributable to the workman having been at the time of accident under the influence of drinks or drugs, the willful disobedience of the workman to an order expressly given or to a rule expressly framed for the purpose of securing the safety of the workman, the willful removal or disregard of the workman of any safety guard or other devices which he knew to have been provided for the purpose of securing the safety of workmen. Where the injury has caused the death of the workman, no defense is available and the employer is liable to pay compensation to the dependents of the deceased workman. Assessment. The Act places the entire liability for compensation on the employer, but there is no obligation on the part of the employer to insure his liability. In case of fatal accidents, many employers in small industry find it difficult to pay compensation to workmen. The Act makes no provision for medical care and treatment in case of injury to a worker. Reference: